My Lords, I thank the Noble Lord the Minister for introducing this statutory instrument, which, as the Noble Lord said, implements the UK's commitment to the agreement between the UK and the Swiss Confederation on mutual recognition in financial services. And I note, looking at the explanation of the SI, it says that this will, as the Minister said, allow the Financial Conduct Authority and the Prudential Regulation Authority to essentially oversee and ensure that nothing is going wrong and have oversight of Swiss operations here. That is perhaps not as reassuring as one might hope, given I note a report in the Times yesterday that the Financial Conduct Authority had privately shared concerns about the 79th Group with the City of London Police 8 months before the group collapsed, owing thousands of people more than £200 million, and is, to quote the Times, suspected of being one of the largest Ponzi schemes in British history. I will note for the record that the company denies any wrongdoing. Nonetheless, the Financial Conduct Authority appears to have had concerns, but did not share those with consumers, who are now very much clearly paying the price. Now, I think it's worth reflecting on the fact that it's a little bit surprising. As the Noble Lord the Minister said, this reflects an agreement that was struck in December 2023 by, of course, the previous government. It said that this was a groundbreaking pact on financial services cooperation. It would enable frictionless cross-border provision of financial services between the UK and Switzerland. It's interesting that a government which has been elected on a promise of change now appears to be delivering exactly the agenda with the same kind of terminology as the previous government that it replaced was doing. And I think it is really important to put on the record and focus on the reality of Swiss banking, which is deeply corrupt, deeply non-transparent. And if we take that, for example, the Tax Justice Network, its financial secrecy index, Switzerland ranks second, and that's not a good result. That's second worst. The UK ranks at number 20, so relatively good comparatively, yet we now appear to be seamlessly linking up these two systems, so linking our system into a more secret system with considerable risks. And it also ranks fifth on the Tax Justice Network's Corporate Tax Haven Index, complicit in multinational companies' tax abuse in particular. The Tax Justice Network estimates the cost to other countries of the Swiss secrecy, the Swiss operations, to be $21 billion a year. Now, I don't know, perhaps this is a specific question to the Noble Lord the Minister, about the worldwide rise of automatic exchange of information notes in the past decade or so, in which governments are supposed to exchange relevant financial information with their peers to help them enforce criminal and tax laws. Switzerland has carved out exceptions to these so-called AEOI notes. So Article 47 of the Federal Act on Banks and Article 127 of the Direct Federal Tax Act have not changed, which still provide for secrecy that's not then is going to be accessing into our system, and we won't be able to see what's happening underneath Swiss law. What's happening is there's been talk of using trusts to replace some of the secrecy instead, but of course trusts are one of the issues that's a major problem. Now, I note particularly the work, and I don't know if the Noble Lord the Minister has seen this, but I'd certainly encourage him to look at it. Maria Gabriela Sarmiento, who completed a PhD at the University of Zaragoza, about the losses of estimated between 20 and 40 billion for corruption practices, of which Switzerland is a significant destination for those money. And over 20 years, assets from at least 33 jurisdictions have been traced to Swiss banks, primarily the proceeds of grand corruption, money laundering and other crimes, and estimates for the value of those in total range from 112 to 514 billion US dollars. The reality is, of course, that the UK and Switzerland are both quite similar. They have expansive banking sectors, sophisticated wealth management services, and market high-value assets. They're prime destinations for the corrupt to stash their money. And just to take one practical example from Transparency International, Carlos São Vicente, former CEO of a partially state-owned insurance company in Angola, embezzled more than $1.2 billion through Bermuda-registered companies. He then transferred substantial sums to Switzerland. Now, this is, of course, one case where someone has been found out, but it's a sample of what a great many people we know are doing without being found out, without me being able to name the details. And I note also, in terms of the Swiss regulations, in 2023, that Swiss regulators inspected their institutions and found that 50% had largely unsatisfactory anti-money laundering systems. So I don't know if the Noble Lord the Minister can tell me that's from 2023, whether there's been significant improvements in all of that area of specifically of money laundering. So, my Lords, it really is very sad that this really important statutory instrument is getting so little attention and so little focus, and that it's happening in this chamber, because this is something very important and very crucial. And we have to situate this in the context where there are grave concerns, and this is not anything like just me expressing these grave concerns about the state of financial stability in our current system, for all kinds of reasons, which I won't go into here, but linking up two systems which have great problems with corruption and lack of transparency, and linking up two of the biggest systems in the world. And I quote the fact that I can quote a former Conservative government minister saying 40% of the world's dirty money goes through the City of London and the British Crown dependencies. I don't have a comparable figure for Switzerland, but I've no doubt it's significant. We are linking up these two sets of money flows, and that has to be a concern.